Good afternoon. My name is Alex Wang. I'm a professor of law here at UCLA. I teach for modern Chinese law and politics here at the law school, and my focus is on environmental regulation. So I'm pleased to be stepping in to moderate this panel on Chinese legal history in a comparative context. It's a roundtable format. The topic is adjudication and the legal profession. And today we will have three speakers. One of our speakers, Professor Yo from Renmin University, at the last moment had a family emergency and cannot join us today. But we still have a wonderful panel. Professor Chen from University of Toronto, Professor Wang Zhiqiang, Wang from who's a professor of law and the dean of the Fudan University Law School, and then Professor Ting Zhang Ting from the University of Maryland. And so with the format we're going to use, this is an informal format without papers. They are going to each open with about 10 minutes on their, they'll tell you about their topic, and then they'll engage in conversation amongst each other for another portion of time. And then I will, my role is relatively modest as timekeeper and also the manager of the question queue. So if you have questions, please feel free to just put them into the chat, and I will take the questions in order. And once we have question time, then we'll turn to the questions. So without further ado, why don't we get started? And we've agreed to go just in the order of the names appearing in the program. So that would mean that Professor Chen from University of Toronto goes first, then Professor Wang second, and then Professor Zhang third. So go ahead, the floor is yours, Professor Chen. Oh, I don't hear you. Let's see, maybe I don't hear you right now. Is that only me, or can anyone hear?
Either.
Okay, yeah, so I think Professor Chen maybe.
Can you hear me now?
Yes, perfect. Yes. Great.
Interesting. Okay. I'm using different equipment, so there's some kind of coordination going on. Again, thank you, Alex, for the introduction, and also thank you all for coming to the roundtable at this late hour. It's my pleasure to start the discussion here first by, I guess, giving a very brief introduction to what I call the legal professional community in late Imperial China, essentially from around 1600 to 1900. So the last 3 centuries or so of the last stage of Imperial China. As many of you know, even in late Imperial China, the Confucian emphasis on education, on moral leadership, and also on persuasion and social harmony instead of coercion, punishments, or conflict resolution through litigation of formal judicial proceedings, very much led to a lot of Confucian literati, scholar officials, as well as I think most educated elites, to put more emphasis on, I think, informal means of dispute resolution rather than legal expertise, legal specialists, or the resort to the formal judicial system. So that has been the traditional understanding of late Imperial Chinese law and society. And that also led to modern students of Chinese history to de-emphasize the importance of law, the importance of legal expertise, and also the importance of legal experts in much of late Imperial China. And I guess, modern Western scholarship, especially influenced by Max Weber and others, their understanding of the lack of legal training among Confucian scholar officials, and also the interpretation of that fact led them to believe that in late Imperial China, local officials adjudicate legal cases often based on moral value or Confucian ideas about social harmony, as well as their subjective feelings, instead of any externally established laws or regulations, let alone codified statutes and so on. So the combination of Confucian, what I call the Confucian moral idealism, and modern or Western Orientalism, legal Orientalism, led modern Chinese legal reformers since the late 19th century also to argue that Chinese law had to be fundamentally transformed and to a great extent had to be Westernized in order to really to be consistent with the modern or Western notion of law and justice and so on. So that has been more or less the traditional understanding of what people have called probably pre-modern or traditional Chinese law and society. And that kind of understanding has also led many modern scholars, both inside China and outside, to really overlook much of the practices, or at least much of the work, as well as the real influence of legal experts throughout much of late Imperial China. Today, I just want to at least briefly sketch out, I think, 3 groups of legal experts who were very important to the operation of the legal system throughout at least the last few centuries of Imperial China. The first group, as many of you know, is also known as litigation masters or shongshi, who were private legal specialists working to provide service for legal service for litigants. So these litigation masters often coached the private litigants on what kind of legal legal arguments they could make in a particular case. They also helped draft the complaints for private litigants, especially those people who could not write or who could not read. And litigation masters for much of the late Imperial China were outlawed, so they were criminalized. At least starting from the 16th century on, they became increasingly stigmatized, and certainly most of the local officials were very hostile and resentful towards these outlawed legal specialists who were often operating underground. Based on actually a recent paper I have written, if we assume one in each of the counties in late Imperial or in Qing Dynasty China, then there would, if we assume there was one at least trained litigation master in each of the counties, then there will be at least 1,700 to 2,000 trained litigation masters at any time during the time period from 1700 to 1900. If we multiply that, then we will get at least, if we assume each of the litigation masters has worked for about 20 years, then we would, I think, have an estimate total of 17,000 to 20,000 trained litigation masters. I'm talking about the trained litigation masters. A lot of litigation masters were not actually trained, even though they could write legal documents for litigants. There was another group of trained legal experts in late Imperial China. They were the judicial officials who received the legal training in the Ministry of Justice. After having worked there for a few years, sometimes for a few decades, these people became really some of the most learned legal experts in late Imperial China, and many of them later were reassigned to local government offices. So they became really some of the best jurists of Qing Dynasty China. Even in those cases, actually, these local officials also often, mostly, as far as I can tell, from my about 2,000 samples I have gathered, these local officials also hired the third group of legal experts. I call them legal advisors. So even the very experienced and skilled judicial officials in the local government offices also hired what they call 木友 or 司法木友, basically legal. I call them legal advisors, private legal specialists who were hired by local officials to advise them on judicial matters, to help them handle judicial as well as other administrative matters and so on. So based on my research and also my understanding, these 3 groups. Oh, I should probably say more about the third group. The legal advisors were, by training, were first Confucian literati. So after 2 to 4 years of legal training, they became legal experts, and they often spent the rest of their life, ranging from 20 to sometimes 50 years in legal practice, helping or advising local officials on all kinds of judicial as well as administrative matters. And based on my research and the kinds of archives as well as other kinds of sources I've gathered, I have, I guess, developed an estimated total about 17,000 to 20,000 of litigation masters, as I mentioned earlier, and 6,000 to 9,000 trained judicial officials, if we assume those who had worked in the Ministry of Justice for at least more than 1 year or so can be considered trained judicial officials. Then for the third group, the legal advisors who were hired by local officials as private advisors on judicial matters, my estimate total was about 30,000 to 60,000 during the time period from around 1700 to 1900. So these are three groups of legal experts formed what I call the legal professional community in Qing Dynasty China. And the emergence of this countrywide, often well-connected community of legal experts made a huge impact on the way legal culture evolved, on the way judicial practice was operated or administered, and also on the way legal knowledge and legal publications were produced, circulated, and also received. Actually, in my paper, I discussed at great length how these different groups were competing for not just juridical capital, if we are going to use some of the concepts of Pierre Bourdieu. They also collaborated in various projects, especially in relation to legal knowledge production and publication. And these, especially some litigation masters, also had sometimes a very, you might call, unfriendly and a certain competitive relationship with the latter two groups, judicial officials and legal advisors. I'm aware of the time, actually. I think it probably already. How much time do I still have, Alex?
You still have about a minute and a half. You're fine.
Okay, so that I think that very brief sketch gives you a sense of how in late Imperial China, justice or judicial administration was not actually so much handled by local officials who were often appointed because of their excellence in I guess, literature, in passing the civil service examination, and in other aspects of their career, instead of their erudition or their legal expertise. But that doesn't mean the legal system in late Imperial China was actually administered by those local officials, or by, especially certainly not by the Confucian literati who didn't have much legal knowledge at all. The fact that there was a countrywide and a large professional community would invite us, certainly would prompt us to rethink many of the important issues concerning late Imperial Chinese law and culture, as well as late Imperial Chinese governance. And also, I think it will invite us to think further about the implications of traditional Chinese culture for the ongoing Chinese strive for so-called rule of law, and to what extent the perceived dramatic departure or break between the post-1911 period and the imperial period before that is more, I think, a product of discursive micropolitics, and certainly the consequence of the three larger discourses I mentioned at the beginning: the Confucian the discourse of Confucian moral idealism, the discourse of legal orientalism, and also the discourse of modernizationism. I think I will stop here just to give enough time for my two co-panelists, and we can come back to discuss some of the detailed implications, but also the kind of configurations I have just, I think, outlined. Alex?
Terrific. So thank you very much. That's a very good start to the conversation. And I will now hand it over to Professor Wang from Zhiqiang Wang, from the Dean of the Fudan University Law School. You'll have 10 minutes, and I will, in the chat, just chat you at 5 minutes and 1 minute left. Great. Oh. Professor Wang.
Okay, yes. Should I get started?
Yes, please.
Did you hear me? Yes. All right, great. Thanks, Alex, for moderating this session, and greetings from Shanghai. Good morning, good afternoon, good evening. This is a very special format of doing our discussion. I mean, we are physically talking in different regions and time zones. For my part, I got up at 5:30, and now it's around 6:30. Last night I heard from Chenjun, the absent panelist who had a family medical emergency. It's not about COVID-19, so I wish everyone is doing well in this special period. And what I'm going to talk about on this big title of Chinese legal history is about the nature and features of adjudication in Imperial China, or you can replace adjudication by other words like law enforcement or judicial administration in this context. When we talk about adjudication in Chinese legal history, it means something more or less different from what we know for this term in the West, particularly in modern Western law. According to Shuzo, a leading Japanese scholar in this field, adjudication in Qing China was run as one segment of administration, or one part in the whole chain of administration. That idea, I think, was shared by some other scholars like Zhi Tongzhu, who used the term of judicial administration to describe the judicial process in his classical work, Local Government in China under the Qing, which is published in 1960. To sum up the general understanding of adjudication in Chinese legal history, it was intrinsically embedded in and intermingled with other affairs of national governance. Firstly, it concerns people and their career. Just as my colleague and co-panelist Chen mentioned, he gave a very brief but comprehensive introduction about this topic. There was indeed a small community of professionals who have expertise in dealing with judicial cases. However, this small group of people will not, according to my understanding, would not confine themselves to this career, particularly for those officials. What they truly expect must be some positions beyond that, say the district magistrate or prefect, governor, or minister of other more prestigious branches or ministries. Meanwhile, it concerns power. Those so-called judicial professionals do not have independent power. There was no such a conception of separation of power in the process of justice at any level. Private secretary had to adjudicate cases by standing in the shoes of his master, considering all the elements that might affect the career interest of that all-purpose principal official. At the central level, officials are more experienced and they use considerable legal knowledge to review dossiers from the provinces. but they were merely subordinates for their minister, who is one agent of the monarch. It was the emperor who dominated the process and administered his power at the last resort. All final judgment of capital cases were subject to the approval by the emperor. There was a form of separation, but what had been separated was not the judicial power, but functional tasks. Additionally, adjudication in traditional China is about the standard of decision making. As I just mentioned, a local official and his subordinates would have to take a large variety of factors in other than legal rules into consideration when making a decision for a given case, because they were supposed to run the entire body of local affairs well. He did not only have to solve a case of COVID-19 misinformation or breach of contract for the reason of force majeure, but to put the situation under control. Thus, Terada Hiroaki, a retired law professor of Tokyo University, labeled Imperial Chinese law law of non-rule, or law not based on rules, as opposed to typical Western law, which is based exclusively on pre-existing rules. And before that, long before that, Max Weber called it Cardi justice or substantive justice, and Philip Wang named it, attracting enormous attention and arousing controversies during the past several decades. Actually, this is not unique, though. As Mian Damashka disclosed that there are other legal traditions where type of adjudication with mixture of law and other social norms widely existed in other societies as well. And last but not least, it concerns judicial responsibility. The fundamental purpose of lawmaking and law applying in Imperial China, as I understand, is to control and supervise the behavior of officials, to prevent them from abusing their power, more than to set up a uniform standards to guarantee similar cases to be decided similarly. Basically, those two aims match each other and point to the same direction, but not always. Judicial responsibility was quite a burden for officials based on effect orientation. So the next question is how comes? Why did it come like this? Quick question, and a quick answer is, as I understand, is the political institutional context that can justify or legitimize the features of adjudication in Imperial China, in particular the style of centralized governing in a big country in the pre-modern era. I don't think I have enough time to go to details of this point. The traditional understanding and the practice of adjudication left a huge amount of legacy, good or bad, to China today. And if our audience and panelists have interest, we can go further on those topics later on. Okay, I will stop here. Thank you.
Terrific. Thank you very much, Dean Wang. And our third and last speaker right now is Professor Zhang from University of Maryland. And a lot of interesting ideas have already been raised, and I'm hoping, I believe you will all expand on them in your dialogue afterwards, right? So, Professor Zhang, you have 10 minutes to make your presentation now. Thank you.
Okay, thank you, Alex. Okay, hello everyone. So I am here to introduce a little bit about the circulation of legal information in early modern China. So I am a historian, so I work on the history, use the methodologies of print culture as well as legal history. So I will introduce some of my own thoughts about how the printing revolution, which happened in China since around like 1550s in the late Ming period, but continue in the Qing period. So how this commercial printing revolution impact on Chinese law and legal culture. So I think my talk is really very closely associated, related with the rise of the legal experts communities that Professor Chen had just talked about, because many of the editors of my law books, they were the private legal advisors or so-called litigation masters, and the target readers were also of those very specialized legal experts communities. So I think for the impact, the commercial printing revolution in late imperial China had a huge impact on the way of circulation of legal information, as well as the production of legal knowledge, and also it has impact on the applications of the laws, and also it has impact on the judicial authority in many cases in the Qing period, at least. So before the commercial printing revolution in China, most of the law books, they were published by official publishers. And so the legal knowledge, especially accurate legal knowledge and the accurate legal information, was by and large monopolized by the state, and they were circulated within the bureaucracy. However, after the commercial printing revolution, the vast majority of the law books that were produced in the Qing period, they were actually commercially published. And the commercial publishers and non-official editors, and many of them, they were private legal advisors, they became the basically dominant force to produce legal knowledge in the book market. And also, there was a huge commercial publishing boom on the books related to the law, so that there were a huge number of law books that were produced in the Qing period. And also the Qing book market not only produced the books for the legal experts, but also it's produced many popular genres, including the so-called Litigation Masters handbooks, or probably the more precise, accurate translation will be popular legal handbooks. And also the everyday encyclopedias also have some sections about legal information. Also, like the court case fictions have some literature part about the law. And also the commercial printing boom also contributed to the much wider dissemination of legal knowledge, especially beyond the bureaucracy in the society. I think it's also related with the rise of those non-official legal experts, like the litigation masters, as well as private legal advisors. And also because the the legal knowledge, especially relatively accurate legal knowledge, were more available to the people in the Qing period. So there was a rise of popular legal consciousness, and it's also contributed to the many different changes in the local litigation process, litigation practice in local courts. And also, in addition to that, we can also see the decline of the state monopoly over law and especially over legal information, legal knowledge, because many of the knowledge and the information, relatively authoritative legal information, was commercially produced by non-official experts. So it has a huge impact on the legal authority, at least in terms of legal knowledge in the Qing period. So here, I will share the screen about an example. This is, so here you can see, this is the one of the example of the impact of the printing on the early modern Chinese law is the Great Qing Code. So the Great Qing Code is the most important book in the Qing legal world. It's the most authoritative book, and it's included almost all the important state promulgated statutes and sub-statutes in the code. And the code, so far I have found around like 131 different editions of the Great Qing Code that were published in the Qing period. And among them, only 8 were published by the Imperial Publishing House. Here you can see the picture. This is the Wingdian Imperial Publishing House. And only 3 were published by provincial or local government. But there were over 120 editions. They were produced by commercial publishers. And those imperial editions and other official editions, they have their own, in addition to their limited number of the editions, they have their own problems. For example, for the imperial editions, they were printed in a very small number. So the print run was quite small. It's only issued to high-ranking judicial officials. So, sub-provincial officials probably could not receive the imperial editions at all throughout the Qing period. And also, the imperial editions were published very, very slowly. And so it's usually outdated, when it was, finished the publishing process. So that's why the imperial editions was never popular among the readers. So the commercial editions basically filled the gap of the imperial editions and became the most widely used books, not only to the people outside the bureaucracy, but within the bureaucracy. Those judicial officials, they bought commercial editions and they rely on those commercial editions to sentence legal cases. So the most interesting thing about those commercial editions of the code is not only its numbers, not only its huge numbers, a lot more than the imperial editions. I think the most interesting thing is that they basically changed the content of the code in those commercial editions. So here are very typical imperial editions. So both of them, they are using the one register printing format. So the imperial editions, all the imperial editions in the Qing period, they include only imperially promulgated statutes and sub-statutes, as well as some officially approved commentaries, but the number was very, very few. So the most important part of those imperial editions of the code, they were imperially promulgated statutes and sub-statutes. So the commercial editions are quite different stories. So those commercial editors, especially those editors after the mid-Qing period, they add a large number of additional legal information into the commercial editions of the code. So for example, this is a commercial edition printed in 1796 in Hangzhou. And so they divided, those commercial editors, they divided each page into 3 horizontal registers. And in the upper register, they include a cross index. And in the middle register, they included a large number of private commentaries, case precedents, administrative regulations, imperial edicts, etc. and also only the lower register included the part of the Imperial Editions, those imperially promulgated statutes and sub-statutes, and also official commentaries, but they also included private commentaries printed together with the official commentaries in the lower register. Okay, so I also so this is the way that, because they, and this is not the only case of they're using the 3-register format. Almost all the commercial editions of the code published after the 1790s, they adopted the same 3-register printing format, and the Imperial Edition, the printing format, it was totally discarded by those commercial publishers. They basically changed the format of the code. So I think I think, you know, in the final part, I will talk a little bit about you know, the comparative perspective, especially regarding the impact of the printing revolution on the law from the you know, when a little bit comparison between early modern China and early modern England, because each of the society has experienced a lot, and the printing as a region really had an impact, huge impact on the law and legal culture in both of the states. So I think there are a lot of similarities regarding the impact if we compare China with England in the early modern period. So the printing definitely contributed to the wider dissemination of legal knowledge. It's also contributed to the change in content, organization, and the presentations of the laws through the editing and the printing process. And also the printing revolution also contributed to the rising accessibility and the utility of commentaries and case precedents in judicial practice in both of the societies. However, the most striking part when I do the comparison with these two societies is actually the state control over the circulation of legal information and the circulation of legal knowledge. I find that, to my surprise, even though that the Qing has a very, very strong government and with the called you know, authoritarian government, compared with early modern England, Qing China had a broader and more competitive and more dynamic market for the law books in a much less regulated environment. So in England, London is definitely the print center of, you know, most of the law books, and also they have the, you know, the government established what is so-called the king printer that have the monopoly of printing all the statutes and the proclamations from the king, and also they have established the common law patent, which gave the monopoly of only one printer in London to print the law books regarding the common laws. And also then this monopoly, the common law patent, only started, you know, to collapse in the 1780s, and after that, only after that, the market started to boom about law books. China has a very different story. There were basically no copy, you know, modern sense or even pre-modern sense copyright law in China. There were very, very few government regulations. And also China has also had multiple printing centers regarding printing law books. Not only, you know, we have the printing centers in Lower Yangtze area, but we also have other cities like Beijing, also like Guangzhou, and like those in Sichuan, even in those Jiangxi area, they produce, all of them, they produce law books. So I think regarding this, those printing revolution has a huge impact on the Chinese law and legal culture, and also it has huge impact on the transformation, the formation and the transformation of legal expert communities in early modern China. Okay, that's my presentation.
Terrific, Professor Zhang. So, so a lot of great information. And for those who have joined late, what the format now, our speakers have each spoken for about 10 minutes, and they're now going to engage in some conversation about what they've discussed for a certain amount of time, and then we'll start taking questions. But again, feel free to start submitting questions through the chat if you have them, and I'll gather them and raise them in the subsequent Q&A session. So please go ahead, Professors Chen, Wang, and Zhang, lead the way as to how you'd like to do the next discussion period.
Zhiqiang, I think probably we can open up the floor and then actually let the questions from the audience to generate further discussion. How about that?
Would you rather do it in that way?
Thank you. Yes, I agree.
Okay.
Yeah.
Ting,
Okay.
how about you?
Okay, sure.
Okay.
Okay.
Yeah. So audience, please feel free to put questions into the chat. You know, I might just begin with a very basic question for someone who doesn't closely follow legal history. Can you say something about what are the kind of conventional wisdoms that you are each responding to at the current moment? Right. There have been some famous research across the decades that are responding to misconceptions about Chinese law. What are those misconceptions these days that you all are responding to?
Zhiqiang, do you want to start, or we do the same order?
Order, yeah, yes, please, yeah.
Okay. As I outlined at the beginning of my very short introduction, I was my own research project is in response to the kind of the three I call the three triple bind for students, modern students of Chinese history. So one is the kind of traditional Confucian emphasis on kind of less formal mechanism for resolving disputes, but also de-emphasis on legal expertise, legal specialists' role in shaping Chinese law and society, at least through much of imperial China. But also, there has been the kind of the Weberian notion of Chinese law as Kali justice, under which under imperial Chinese legal system, especially local officials were mostly just Confucian literati without legal training. So their adjudication was mostly based on or influenced by their moral sensibilities and how they understood to be fairness or justice in kind of Confucian ideal way, instead of formal legal mechanisms or judicial system. And also there has been the ongoing modernist, I would argue, tendency to really invalidate or delegitimize whatever cultural legacy from the past. So in the process to carve out a modern Chinese legal system, more or less consistent or similar to what Euro-American societies have had. So in a sense of that, I think those are three major, I would argue, discourses or epistemological frameworks were some of the concerns underlying my own analysis and also my book-length project. Zhiqiang?
Thank you.
Sure.
Professor Wang.
Okay. Okay, I just want to add something to my last topic and to respond to the issue raised by Alex, which is about the bridge between the past and present. Actually, as we can see from the development of law and adjudication in China today, we still see the phenomenon that law exists like an indispensable part of national governing, as a chain, as a part of the whole picture of administration. And the judge in China today is supposed to take into his consideration different factors like circumstances, like policy, like morals, and orderly understanding of reasoning, which are factors other than just legal rules, to make his or her decision on a legal case. So I think it's still a permanent existence of tradition in China today in terms of the features of adjudication. And I think that's closely related to the background I just described in my presentation, which is the political institutional context. And the separation of power is limited, and local governance style is plays a role as a continuity of the traditional format. Yeah, I just want to add this point.
Thank you, Professor Zhang.
Okay.
Okay, so I think the main conversation of my research is to with the previous assumption, very similar to with Li's argument about the previous assumption about the Chinese law and legal culture, especially regarding the legal knowledge, because it dated back to the Orientalist view of China, dated back to Max Weber. He basically argued that the Chinese legal system was totally a failure, was a total failed, and there was no legal education system in China, and that's why officials and as well both the officials as well as the common people they didn't have access to the laws, and and therefore none of both of the officials and the common people didn't know much about the law. So this is the main things that I want to argue against in my book. And so in my book, I basically argue that in my research, I basically argue that even though that there was no established legal education system in China, but there were a large number of books that are available on the market. And if you're, the Chinese law books are not that difficult to read, especially for those, for those officials after years of like training of Confucian classics, they were advanced readers, and they have access to the, to the law books. And in addition to that, I think even for the common people, in the Qing period, they have many different access to the legal information, including through popular genres of law books like the Litigation Masters handbooks, like from court case fictions, but also they could get legal information from other channels like the community legal, the community lectures, etc. So the main things that I'm arguing against is the previous assumption that there were basically none of the people are quite very familiar with the law in the late imperial period, and they didn't have access to the legal information, and also the state monopolized the production and the circulation of legal information and legal knowledge in China.
Very interesting. So we have a few questions here in the chat. I'll go to Professor John Reitz from University of Iowa, if I'm not mistaken. Please feel free to go ahead and ask your question.
Yes, correct. Thank you, Alex. My name is John Reitz. I'm from the University of Iowa. I'm very interested in your talks and your projects. They sound very important to me. Clearly, the traditional view of China needs to be challenged. The traditional view of Chinese law needs to be challenged and expanded, and I'm sure we can learn a lot more. Could you? My question for all of you is I wondered if you could give us a little feel of what the substance of this legal literature that you are showing was circulating in China, was available. And what I'm really interested in is whether there were any commentaries on actual cases or commentaries on hypothetical cases. What I'm thinking is that when one studies early law in some other jurisdictions, particularly say Roman law, you find this rich body of juristic law that is the law by the jurists, commenting on how law applies in specific cases. And I'm wondering whether there was literature like that in China. I have not been able yet to find references to that kind of law. There's a lot of references to the sort of collections of stories about law that were, I understood, were circulating in China and are, I'm sorry to say, made known in the West through the Judge D novels. I don't know whether you know those, but they were novels written by Van Gulik, who was a Dutch Dutch diplomat who was fluent in Chinese and read a lot of these things, and then made a sort of a westernized version of them for the West. And I don't know how representative those are. I'm not saying they are, but I'm afraid that's been the impression that's been given by his work. And so I'm wondering, was there those were stories in which the mandarins, the chief judge officials in each section were sort of the heroes because of the way they ferreted out information. You know, they were sort of detective novels, really. But what I want to know is, was there some sort of juristic literature that was circulating too? Thank you.
I'm sure my co-panelists can add more, but I think in terms of the I think you mentioned kind of the substantive literature about Chinese law, probably. Certainly there actually starting from at least as early as the Han Dynasty, that could be 3rd century BCE or even up until 3rd century CE. There were already, body, at least there was a body of literature, actually not literature, body of legal material, including hypothetical cases discussing how, a particular legal provision or statute should be applied to a hypothetical case. So that's to answer one of your questions about whether actually China or Imperial China had a long tradition of using hypothetical cases to elucidate legal rules, or to at least, explain how a certain legal statute or statutory provision should be applied to a particular circumstance. But also, as I think my co-panelist Ting Zhang has particularly mentioned, the various kinds of commentaries on the imperial law codes themselves. At least by the late 19th century, there had already been quite a significant body of different kinds of treaties by imperial Chinese jurists, elaborating, the coherence of one statute from one statute to another, and also coherence or lack of coherence, if they were critiquing some aspects of the law code among different statutes. So Xue Yunsen is one example. To actually, I think that goes back to Professor Zhang raised the question about the coherence. Xue Yunsen's treatise on the Qing Code probably can be considered one of the best expositions on the kinds of coherent legal reasoning within the law code, but also he was very critical about certain aspects of the law code which for him were not as coherent or consistently applied in practice as he would like them to be. So I think there had been a long tradition among Chinese imperial jurists, even among some of the imperial officials who were experts on law in that regard. But I can add more, but I want to give my co-panelists a chance also to respond to that question as well.
Okay, I just briefly add 2 points to the beautiful response made by Chen. One is that in terms of coherence, I fully agree that there are some attempt to set up a coherent body of jurisprudence or systematic commentary to interpret legal rules in the format of Confucian ideology, but actually they are full of technical skills, not only those ideological principles. And the second point I want to make is that the focus, if we compare it to the Roman law or Roman jurist contribution on legal science, is on the side of criminal factors. And most of the law books as Zhang Ting mentioned, as I understand, is about how to deal with a criminal case. I don't know how Zhang Ting define law books. Do you consider those collection of civil case judgments into consideration? But I think in terms of legal coherence, a major focus in traditional China is on the aspect of criminal side. Sorry, that my
I think the most interesting thing about the literature regarding the law in late imperial period is cover all different kinds of genres. So there were genres that were produced for high experts, like for those judicial officials, for those private legal advisors, including a large number of commentaries that Professor Chen has just commented, and a large number of case precedents that were circulated in the Qing period, and also a large number of the Great Qing Code. In addition to that, they have also official handbooks and also like administrative handbooks, and both of them they included a large number of legal information. They're recording those judicial officials' experience in dealing with cases and their advice about how to deal with legal cases, how to deal with this judicial administration, and all kinds of like procedures and instructions. And in addition to that, they have a lot of popular genres, like you mentioned Judge Di's case, celebrity case of Judge Di is a kind of like a translation of the Qing court case fiction, and it's not the only one. There are a lot. There is very popular genre in the Qing period. Those court case fictions, they have a large number of fiction that were related with those cases, relating with the laws that were produced in the Qing period. And also, I think to me one of the most important and the interesting genre is those so-called secret handbook for litigation masters. And in those, so-called secret, litigation master handbooks, there were no secret at all. They were sold openly on the market, although it was banned by the Qing government. But it was, it reappeared on the market after like the decades of ban. In those litigation masters secret handbooks, there were many different kinds of information. There were miscellaneous information together compiled into those books, including what you mentioned the hypothetical cases. And it's not only in those high genres like produced for the legal experts. In the litigation masters handbook, there are a lot of accusations and counter accusations. They were regarding the hypothetical cases in the local court. So it's very, very interesting to read. And in addition to that, in those litigation masters handbooks, they have the rim songs for statutes and sub-statutes. So basically they simplify those statutes and sub-statutes, and they put them into the short songs, and for people to recite and to remember those laws. And there were also hypothetical questions and answers regarding the very real litigation problems in the local society. So in other words, I think there were all kinds of genres that were produced in the late imperial period, cover all different sides of the society from the top to the bottom.
Great. Can people hear me? My microphone might be off. Can you hear me right now?
Yeah.
Yeah, okay, great. Okay, so I think the next question, I got kicked off for just a moment, but I think the next person in the queue was Athena Safila. I believe you're coming to us from Germany, is that correct? Okay, please go ahead and pose your question.
Do you hear? Okay,
yeah.
Thank you. Thank you very much. First, thank you for the very informative evening, the very informative panel. My questions refer firstly to the evidence system in imperial process. I would like to know how was this evidence proceedings scheduled? Was the judge free to decide what kind of evidence is required or had to follow, as in Europe, a strong hierarchical system of presumptions. In Europe at that time, three testimonies upon a fact means the fact is true. Less than 2 testimonies means the fact is presumed as not true. Women could not testify, was not tested as habeles. Women was tested as inhabeles, not honorary to testify. And the judge had to follow this pathway till the end, was bound. The judge was not free to evaluate everything, every source of information. Was the same thing in China? Was there a judicial oath when a litigant had to give an oath in Europe in some cases and gave the oath to the religion, then the fact was given as true, is presumed as true. What happened in China at that time in the evidence proceedings? How much liberty had the judge, and what kind of presumptions of truth existed? This is my first question. And the second question was the jury. Did we have a jury at that time as an expression of people mind, as a collaboration of a judge coming from the people directly and not an imperial instructed judge? Had we a criminal system with a participation of a jury or not, and for what reason? Thank you very much.
Great. So we have 2 questions, one about evidence and one about whether there is a jury at that time in China.
Probably,
would anyone like to?
It's easier to answer the second question first. In the late Imperial China, throughout the Imperial China, there was no jury. That's one of the major difference between the Anglo-American system and the Imperial Chinese legal system. In terms of the assumption, I think it's just there was not as much faith in the kind of the commoners' testimonies as more convincing or more I guess trustworthy than the evidence the imperial judges were supposed to gather. So in a sense, the local officials or the judges, imperial judges, were expected to be able to discern whatever evidence they could gather under the circumstances. The ordinary people could be important to the judicial decision or the adjudication process as witnesses, or sometimes as parties, or at least corroborators of other witnesses' testimony, I think, in that case. But I mean, very briefly about your first question, there was no judicial oath either, at least in the imperial period. I think in your written question, you asked about whether certain witnesses were considered unfit or fit for providing testimonies. You mentioned women. In Imperial Chinese, under the Imperial Chinese legal system, women were not excluded from providing testimonies per se, but because of the Confucian notion that women should not be, if they had other choices, they should not actually go to the court, should not expose themselves to the public scrutiny and so on. So normally, women would not appear in a court of hearing unless they had no other adults, male adults, to turn to for judicial proceedings and so on. So if they had adult sons, if they had a husband and other kind of male relatives who could substitute for them to bring their judicial proceedings to the court, women would not, at least were not expected to be in a court of law. But we know in many cases, actually, women brought their cases from the local place, whatever their hometown, to the capital, actually, to bring their complaint to the emperor, presumably. So it was not, women were not precluded from judicial proceedings or from testifying against the other side of the dispute in itself. But women did have to overcome some judicial hurdles or some social hurdles in order to, I guess, resort to the legal system. The judges had a lot of discretion, to put it mildly, to decide what kind of evidence could be admitted. But there was also the codified legal system. There was the imperial code, law code, Ting has just mentioned. The judges, especially in major criminal cases, the judges had to follow more or less the written, published and actually enacted legal procedures. Otherwise, they could be subject to serious penalties as well for basically either overstepping their boundaries or for breaking certain kind of procedural rules and so on. I will stop here for two panelists.
Thank you.
Okay, I agree with Chen regarding the issues about jury and oath in Imperial China. I want to add 2 points about the issue of evidence. One is about the standard of evidence in adjudicating cases. The second is about torture, judicial torture, to get evidence in criminal cases. And about the standard of evidence, there are no explicit standard described in the law code, but there had been some different standards in different cases. Basically speaking, in civil cases, there's no such a clear standard of proof sufficiency, and it's fully up to the discretion of local district magistrate. And the evidence came from the plaintiffs and the defendants, and sometimes the government will convene witness to testify in the courtroom, but it's basically the obligation of the 2 parties or those parties to present their witnesses, at least to present the information about the evidence or witnesses. Yeah. But in criminal cases, in contrast, it's fully in the hand and the obligation of the government to collect all the evidence. And they also had to make the evidence sufficiently enough to meet a very high standard. I would call that coherence of all evidence, meaning the testimonies, the physical evidence, other proofs have to match with each other without any gaps. And that's the standards higher than so-called legal proof in European countries, or beyond the reasonable doubt standard in Anglo-American law. And this is about the standard of evidence, and the judicial torture is also an important topic in terms of evidence, because in criminal cases, the confession is indispensable for capital cases in Imperial China. And it's the government that had to collect evidence, other evidence, and the confession from the accused. As you can imagine, judicial torture would be inevitable in the process of extracting confession. And I think it's a very similar phenomenon in European countries in medieval times. But it was abolished in early modern period, at least very fast after the French Revolution. And Professor John Lambine had a great description and explanation of abolition of judicial torture in European countries, but in China, it's not so easy to be abolished, even nowadays, because the requirement and high standard of evidence still exists in modern Chinese law and adjudication. Yeah. Okay, I stop here.
Okay, so I think Professor Chen and Professor Wang have provided, excellent answers to this question. Here, I only want to add 2 details, and they're like smaller details. And so, for one thing about the oath, even though that the official oath is there was no official oath, in late Imperial Chinese court. However, there were unofficial oaths. If you're interested in that topic, you can read Paul Katz's book called Divine Justice, and in that book, he explored the unofficial oaths that were usually taken place before the city guard in China, between those judicial officials and those witnesses and those those criminals or suspects, and they made the oath, and the punishments for the oath, based on the popular religious belief in China is that if they said the lies, they will be punished in the underworld court, in the afterlife. So this is one thing that I want to mention. Another thing about the evidence here, I just want to mention the forensic evidence in late Imperial China is very standardized, and they even issue the printed form to those coroners in the local courts for them to fill out. And all the information in the forensic forms, they were standardized. They should be based on the official, the imperially promulgated, the imperially authorized forensic handbook called the washing away of the wrong. So in terms of the forensic evidence, it's very standardized in late Imperial China, and it has a lot of regulations and other things regarding how to fill those forms, and they wanted to really standardize the information in terms of the forensic evidence in serious criminal cases.
Terrific. So we have a few other questions in the queue. I think the next is from Roy Sturgeon from Tulane, if I'm not mistaken. Please go ahead. I think you're still muted now.
Okay, can you hear me now?
Great, yes.
Thank you for the excellent panel. My question is for Professor Zhang, and I'll just read it as I typed it in here a few minutes ago. Regarding the privately published Qing Code commentaries, do we know anything about who actually wrote them? Like who these people were and what their qualifications were for writing a commentary? And also, do we know whether some of these commentaries were considered more authoritative in their time than others?
Mm-hmm. Yes and yes. So I think both my research and Professor Chen's research is really related to those 2 questions. And so for the first question, yes, and there were majorly 2 groups of people who produced those commentaries. The first group is those judicial officials, including Xun, which like Professor Chen has mentioned about. And the other group is probably more important group in the Qing period is those private legal advisors. So there were a large number of commentaries that were produced by those private legal advisors, and there were really several books or several commentaries that were viewed more authoritative than the others, including Shen Zhiqi's Daqing Lü Jizhu, as well as and also I think another there Shen Zhiqi is among them. There are at least a number of books, a number of commentaries that were viewed be more authoritative, more reliable than the other books. I think Professor Chen will provide some more information about that. I think this is probably more related to your research instead of my research.
Sure, I can add more, but I think Zhang has written a wonderful book about the circulation, the production circulation, and also reception of not just the Qing code, but also legal knowledge in general. In my own research about the legal advisors, I call them legal advisors, basically the private advisors to local officials across the Qing Empire. I've gathered more than 2,000 of them so far. I think we certainly for the most influential commentaries that were published and are still available to modern scholars, we know most of them, the authors of those commentaries. We also, I think, had a very good sense of where they circulate based on the, the different, oftentimes more than 20 or 30 different editions that are still available for us to study. So I published one article, but also I have one chapter about the production and circulation of these legal treaties, handbooks, and commentaries. What I consider them as sites of contestation among different stakeholders in the larger professional community or larger juridical field for juridical capture as well as other kinds of social, cultural, political capture as well. So in a sense, this is much more dynamic than we used to believe. We assume that because it was Confucian society, law was unimportant or legal experts were not, treated as or were not taken seriously. But in fact, the juridical field was far more dynamic, far more active, far more important than most of pre-existing scholarship or the traditional historiography had led us to assume.
Great, thank you. So we have another question about legal knowledge from Yu Wang, and gets us into touches on sort of how people are receiving this legal knowledge. That's something we've talked relatively less about today. But maybe if I could ask you, Yu Wang, to kind of state your question. People can see it in the chat, but maybe if I could ask you to just ask it.
Okay, thanks, professors, for that wonderful presentation. What I'm thinking about is, from a multimedia perspective, which is not only about, the writings, advices, and the publication of the Great Ting Code in the case of Professor Zhang, and then the pamphlets and the booklets published by legal advisors from Professor Li's perspective, but also, say, the circulation of popular literature, especially the detective stories. And I wonder how, well, in fact, are there any cases that we have, legal advisors or people, equipped with legal knowledge writing about or commenting on these legal stories? And I wonder how these two types of legal knowledge, whether they ever communicated or negotiated. Thanks.
That's, I think, a trick question. I know Margaret Wang, a faculty member, actually, I think, of Professor Xiaoping Chong's colleague at the University of Houston, wrote a chapter to one of my edit volumes where she documented how, popular literature influenced or represented justice or judicial administration, but also influenced how people's understanding of the legal system. I haven't found a lot of I think cases in which actually the local officials or the advisors directly interacted with the kinds of legal knowledge. I think that's your question was heading. The legal knowledge people acquired through popular literature, but I think we can assume that the popular ordinary litigants who otherwise didn't study law systematically had to rely upon the kind of popular or literary version. What Professor Zhang mentioned, the Judge D's story. So the kind of popularized version of law or notion of justice as their basis of how the legal system might have been working. Apparently, there was a huge gap between, the kind of Judge D stories and also the stories about the judicial, the legal system or judicial operation represented by the kinds of cases translated by Professor Robert Hagel of Washington University into English. So I think there would have been a lot of conversations between the popular version or literary version or rendering of the legal system and the official operation or administration of the legal system. But I don't think one can find a lot of cases in which actually the judges or the legal advisor directly mention literature or kind of the literary sources of their decision and so on. But I'm certainly open to hearing more from my co-panelists and see how they felt about the same question.
Okay, do you want to add anything, Professor Wang?
Zhiqiang, do you want to add more?
Yes, I want to say one word. It's very popular among young scholars who are working on the topic of law and literature, particularly from a historical perspective. And there are some literature on this issue by describing the law enforcement in ancient literature. And I think that's one point I want to add.
Okay, so I think because those court case fiction, they were banned during the Qing period, so they were basically illegal books. So probably very few people, especially educated elites, they will mention that people in their writings. But based on the content of those court case fiction, those 公案小说, we can see that many of the authors, they were quite familiar with the laws, and it is possible that they have some experience dealing with the laws. They were probably like lower level officials, or more possibly like the so-called litigation masters. They have the real experience dealing with the cases. They have some information about the cases. I think one of the good example is a Qing fiction called 九命奇冤, and it is from the based on real case happening in the Qing period, very, very popular in Qing at the time. And I think if you're interested, they were based on the real case, based on the real case records, and they record very, very details about the case, about the confessions, and about the story, as well as about the sentences, and all the information in that fiction is very, very accurate. So there was an article in a book edited by Robert Hegel called Writing and Law in Late Imperial China. You can find one article talking about 九命奇冤, the nine murders case. And also regarding the second question, so the connections between the knowledge or information in different fields, especially regarding the experts knowledge with those popular knowledge, I think you can find very, very interesting cases in the litigation masters handbooks. So in those handbooks, you can because those litigation masters secret handbooks, they were a mixed genre. They included all kinds of legal information. Some of the information are very specialized, very expert, towards the experts, including the large section of statutes and sub-statutes directly copied from the code. But also we have very, very interesting stories that were included in those litigation masters handbooks, and many of the stories in those handbooks, in those cases, later turned out to be part of the court case fiction or other fictions. So you will find that the flood of genres, that the similar, this one case, especially some infamous cases, they appear not only in one genre but also in other genres. So they basically have the base information from the practice, and they put them into different use in different genres.
Great, thank you. So we have about 6 minutes left. Are there other questions right now? Okay, another question from Roy Sturgeon. Have any of the litigation master handbooks been translated in English? So there's that question. I'll also just throw in one other question of my own. Just you're talking about revision of attitudes towards the legal system at this time. Is there any revision needed to our sense of public attitudes towards the law of this time? I guess I use somewhat, some of the very minimal legal history materials I give my students talk about citizens really having a lot of aversion to getting involved in the law. I don't know if that needs to be revised, or what do we know these days about this?
So, Alex, your question is about the late imperial period, I suppose.
Yeah, the period that you're talking. Yeah.
Yeah, I mean, I think I'm personally inclined to think that we need to do that revision as well. It's not just, you know, we know much more about the legal experts, their role in shaping law in society, and also the way legal knowledge was circulated, was, you know, utilized, but also how the ordinary people made use of the legal system and how they perceived the value of the legal system to their daily life. I mean, I think we have already, over the last 30 years or so, we have already seen a stream of legal publications which have provided a lot of, I think, new material, new perspectives on the importance of the legal system, not just for the rulers or the ruling class, but also for the ordinary people. Back in the 1990s, I think we already saw books, documenting how widely people used, for example, all kinds of legal instruments to structure their life, to structure their social relations, even to secure some kind of, assurance for their graveyard after they passed away from this world. So in a sense, I think certainly there is a great need for that revision as well. But I think going back to the earlier question about Roy's question about litigation master handbooks, as far as I know, I haven't seen any translation of either litigation master's handbook or handbook by legal advisors or handbook. There has only been a partial translation of one Qing local officials handbook by Huang Liu Hong Liu Hui Quan Su, Fu Hui Quan Su. That was the original translation was actually a verbatim kind of full translation, but somehow the publisher was concerned about the cost. So as far as I know, the eventual published version was only a partial translation. So that was already that proved to be very useful for at least non-Chinese speakers, scholars who study China but don't have the language capacity to read the original documents. So I think this also is related to Professor Zhang Rei's question about lack of, at least apparently in European languages, lack of treaties or Chinese treaties on the kind of reasoning, the coherence of Chinese legal system. That's mostly because we don't have anyone who either has the time or the the language skill to translate a full treatise into European language, especially nowadays when translation is not counted as a serious scholarship, at least in most cases. I wanted to to translate something like that, but probably I'm not up to that point yet. Probably when I have retired from, I don't know, my current position, I might be able to do something like that.
Great. We have one last question about the appeal system, where there's specialized appeal litigation masters and advisors. If you'd like to address that, and if there's any last words you would each like to say as we wrap up, please feel free.
I will leave this question for my two co-panelists because they didn't answer in the first question, in the last question. Okay. Zhiqiang and Ting, feel free to.
Yeah. About the appeal system, yes, they are something functionally equivalent to the appeal system. It's called automatic review system for criminal cases demanding several punishment. The case dossiers will be automatically submitted to the higher level official to review, sometimes in person, or the witnesses and the accused defendant will be escorted to the higher level officials to interrogate in person. And the final judgment will be reviewed in capital cases by the central government and the emperor himself to make the final decision. And I want to go back a little bit to the point about the legal knowledge of commoners in Imperial China. I want to add 2 points. One is, as I remember, there was a study about cases in fiction. Professor Xu Zhongming disclosed the fact that he compared the legal cases described in fiction with the legal code, with law code, and his finding is that in Ming and Qing fictions, this judgment in the fiction match the law code. That means a knowledge of those authors of fictions are correct about the law. And the second point I want to add is about the scale of litigation of local people. It's described by the Japanese scholar Suzuma that it was a litigious society in Ming and Qing, later Imperial Chinese society. It's very popular or very common to bring legal actions in courtroom, to magistrate courtroom to solve their disputes. And the knowledge, the demand of legal knowledge is tremendous. Yeah.
Okay, so if you're interested in this topic, I really recommended one very important article written by the late Zhang called "I Will Take It All the Way to Beijing." It's talking about the capital appeal system, and also regarding the second part, specialized appeal litigation masters. If I'm not wrong, I remember in Melissa McCauley's book, Social Power and Legal Culture, which focused on the litigation masters in late Imperial China, she did mention there are some, some litigation masters, they were living in Beijing and they were, focused on those capital appeals, and that they will provide like some information for those people, litigants in those capital appeals. And also for the advisors, yes, if they're in the, if you are mentioned, especially in the late Qing period, there is the Provincial Judicial Bureau or Fashenju, and they were in the late Qing period is kind of like specialized in dealing with those appeals, and in those Provincial Judicial Bureau, they have their specialized advisors working on. I think also the advisors for the Provincial Judicial Administrator also, they have their own advisors and dealing with also. I don't think they specialize with the appeal cases, but they definitely will work. Part of their work will be exam of those cases.
Terrific. Well, we've had a wide-ranging discussion. We've reached the end of our time. Maybe we should all give our panelists a round of electronic applause and thank them for their input and their very learned comments. I hope maybe the speakers can stick around, to simulate the sort of after-panel discussion that sometimes happens. If you're willing to stick around for a few minutes, maybe people who won't have additional questions can stay in this more informal setting. Otherwise, see you all tomorrow for the rest of the conference.
Alex and all of I think the people in the audience, thank you all for coming, and also thank Alex for chairing this roundtable discussion. I'm willing to stick around for a few minutes if there's, there are further questions that we haven't got a chance to answer. But thank you again for attending this roundtable discussion. I think I have learned more from the audience than certainly from myself. Thanks again, Alex.
Great. Yeah, no problem. This is I learned a lot here, so I think very successful panel. And for people who are sticking around, feel free. I guess we have a slightly smaller group. If anyone has any additional questions, feel free to just chime in, I suppose. Or you can raise your hand if you'd like, but feel free to just ask, I suppose, if you'd like.
I also want to thank you everyone for coming, and I really have had a great time talking with everyone in this panel.
Thank you for those stimulating comments and questions. I appreciate Alex and the audience and my co-panelists. Thank you.
Great. Okay. Well, we may not have any additional questions. I think we already had a very good discussion, and I look forward to. I've already been looking up the books that you guys have written, and look forward to adding it to my stack of things to read. So I'm glad I got to learn a little bit more about your work. So it's a benefit for me. Okay, terrific. Okay. Well. Why don't we sign off then? So, so thank you all, and
thank you.
See you all again soon. Okay, take care.
Sure. Thanks. Take care.
Bye.
Take care.
Thanks to you all. Bye.
Bye.